So our second speaker, I'm pleased to have with us, is Galina Arapova, who is a lawyer and director and senior media lawyer at the Russian-based NGO, the Mass Media Defense Center. She's litigated a large number of cases in Russia, including a number of defamation cases, and has taken cases to the European Court. She also finds time, I don't quite know how, to write and edit books and to teach at the School of Journalism. And she's going to tell us about some of the problems that she's been encountering in Russia recently. Thank you very much.
Thank you. Thank you, Jill. That's all quite correct, even though I don't write that many books, so I prefer practice law. That's much more exciting. I apologize, I don't have exciting pictures, even though we do have some quite exciting investigative stories lately coming up in Russian media with not the Ghana nobles, but with a high-rank Russian officials. But I thought it would be more practical for the sake of this conference to focus on common issues. Because, of course, I can speak about problems of freedom of expression in Russia for hours, but I'm not sure that that would be that interesting for you. So I was going to focus on a few things which I believe is a common legal problems for the Council of Euro countries. And defamation, which is one of the issues of our panel, is one of them. And I believe that even though practice of European Court on Human Rights on defamation is quite developed, we practicing lawyers still face some complications in implementation of these principles on domestic level, which is a shame. And I think that, unfortunately, some developments in recent European Court case law are affecting these problems on domestic level. I'm not going to criticize here a certain lack of knowledge of European Court jurisprudence and principles among legal practitioners in my country or elsewhere, because I don't think it's the key point of our conference. This is a matter of some other discussion. But the very fact that a number of cases are brought before the European Court under Article 10 is still very high. That shows an importance of professional discussion and further development of legal knowledge in this field, and requires common understanding and unified approach in dealing with these cases on both domestic and international level. So I was going to focus on three things, and if I will be too long, I will just skip the last one. Just let me know. First, I will start from criminal defamation. And of course, I'm not going to give any recipes. I think Judge Spano will maybe help us with this, because we always refer to European Court case law to see how we on domestic level have to implement things, what we can offer to domestic judges as the way out of a conflict situation. So I think that I will rather raise issues and questions for further discussion. I will start, as I said, from criminal defamation, which remains enacting provisions in the legislation in many European countries. And Russia is not an exception, unfortunately, and probably is the only country in Europe, if not around the world, which decriminalized defamation first and then half a year later introduced it back to the legislation. So unfortunately, we're still stuck with the criminal defamation, even though sanctions such as imprisonment is no longer in the criminal code. But still, fines as a financial sanction raised radically, and now it's, a person could be punished for criminal libel up to a very high fine for Russian level of living. It's quite catastrophic. It's 80,000, up to 80,000 euros. That how high the criminal fine could be. And we still have provisions remained in the criminal code and for punishing for libel against judges, jurors, prosecutors, and law enforcement officers, and insult of public officials. And even though, as I said, main punishments are in financial area, it's fines, not the imprisonment, but still it can cause quite a serious chilling effect. And no one, of course, wants to find himself or herself in jail or bankrupt or being able to, or not being able to support his or her family. So journalists are trying to avoid. Thus, it's a cause. It's a reason for raising self-censorship, and journalists are trying to avoid critical topics. They started to be afraid of reporting on corruption, governmental corruption, human rights abuses, and lately on protests, because they're being arrested on a daily basis for doing that. So we all know that it's been a long time campaign around Europe for decriminalization of defamation, and media community and media lawyers unfortunately still didn't win this campaign. And I hope that the European Court on Human Rights could contribute more into this by developing a stronger position towards criminal defamation and set a clearer standards and criteria of proportionality when it comes to criminal sanctions of defamation in defamation cases. And the question of violation of freedom of expression is there. European Court on Human Rights, in one of the issues, and times, on this issue, at times differs from case to case. And it gives, and this not a stable position with regards to criminal defamation, unfortunately gives authorities arguments to refuse decriminalizing defamation and go ahead and prosecute journalists and bloggers for defamation under criminal proceedings. In some case, like in Romanian case, Cumpana and Mazarea versus Romania, European Court on Human Rights found violation of Article 10 in criminal conviction of journalists, quite rightly pointed out that criminal sanctions and the accompanying prohibition to practice profession imposed on journalists have been manifestly disproportionate in their nature and severity to the legitimate aim pursued. And I think this is one of the strongest cases that give us more arguments in our litigation against using criminal defamation in media field. European Court also stated in this case that in regulating the exercise of freedom of expression, so as to ensure adequate protection by law of individual reputations, state should avoid taking measures that might deter the media from fulfilling their role of alerting the public of apparent or suspected misuse of public power. In addition, investigative journalists were liable to be inhibited from reporting on matters of public interest if they ran the risk of being sentenced to prison or to prohibition of the exercise of their profession. And we had a similar case in Russia, which is still pending before the European Court. Mass Media Defense Center, where I work, was providing legal defense in a case where a journalist and blogger was publishing on a live journal his short reports on misuse of power by local law enforcement bodies, judges, and corruption in police. And he is quite an impulsive person, I have to say. And since he was not writing those pieces for print media, he was writing that for his personal blog and live journal. He used quite sometimes very expressive language. So he called commercial court judge a crocodile and a marmoset. Marmoset is a kind of like a little monkey. And he called a prosecutor by his nickname. He was writing his stories about him misusing his powers, but he referred to his name as his nickname, which was given to this prosecutor by his colleagues, and the nickname was a tractor driver. And they gave him that nickname because he was not wearing a tidy clothing, that kind of person he was. So a blogger used this nickname, a tractor driver, in his blog, so that, and in addition, the crocodile and marmoset and some other things, that was ground to prosecute him for insult of public officials. But since insult of public officials will not constitute imprisonment, and how you will silence a blogger and a journalist who is writing online? You can just only put him in jail or do something even harsher. So he was prosecuted for other criminal offenses, which he said he didn't commit, for commercial bribery, for false reports to police. And the false reporting to police was connected to the investigation of the crime he was accused of.
Galina, if you could move on to your second topic, that'd be great.
So that case resulted in 3 years of imprisonment for under all accusations, and 2 more years of prohibition to practice journalism as a profession. So this is an example of how criminal defamation could be used to silence journalists for quite a long time. And I believe that European Court could really help us to litigate those cases by being more direct in their position with regards to possible application of criminal defamation provisions on domestic level. I really hope so. So, second topic. My second topic is a conflict between the right of freedom of expression and the right to reputation, which was a subject of our discussion on a previous conference here in Strasbourg in 2008. And this topic was perfectly analyzed and presented by Professor Voorhoff. And I think still, since then, situation didn't really change for the best, because we still have quite a controversial practice under Article 8 and Article 10 when it comes to protection of reputation as a part of a new understanding of a notion of private life. As at some point, the court reassessed the question whether the notion of private life should be extended to include reputation, and then concluded that the court's prior case law had only recognized the existence of such right sporadically, and mostly in cases involving serious allegations which had an inevitable direct effect on applicants' private life, which is true in a way. But this interpretation evolution culminated in Chavi versus France, sorry, I hardly read French, versus France case. And in this case, court, for the first time, identified the existence of a conflict between two rights, the right to freedom of expression and the right to reputation. Even though those rights, each of them doesn't have a certain priority in convention, still it's always difficult to draw a line and find a fair balance between these rights. And in some cases, court identified tension between Article 10's guarantee of freedom of protection of the right to private life and reputation, and Article 10's guarantee to freedom of expression, categorizing the tension as a conflict between rights, competing interests or values. So the fair balance would be found. So in those cases, I just remind that this is Petrina versus Romania, Pfeiffer versus Austria, Romanenko versus Russia, Mahmoudov versus Azerbaijan, Kvechin versus Poland, and quite many others. So this allowed plaintiffs who failed their case on domestic level to come to the European Court and ask to recognize a violation of Article 8. And this particular conflict undermines, to my mind, the previous principles developed by European Court in Article 10 cases. So that doesn't give a clear understanding on domestic level whether domestic courts could apply principles of, let's say, public figures in defamation cases, if they might face European Court's decision saying that denial of a defamation case on domestic level could be found as a violation of Article 8 of the plaintiff on a in domestic court. So this is still a question which I think should be discussed, and it would be good so that this practice would be developed into something more clear for practitioners.
Galina, the last thing I want to do is silence people, and particularly because this is all, it's all fascinating. But I do want to also make sure that we all have a.
Well, I will just, as I said, I will wrap up the last issue. I will just name that the third problem that I wanted to identify, and I think we will just discuss it later with the audience, is using of the laws, data protection laws, and personal data protection laws in particular, to silence journalists who write on issues related to particular people. And the journalists always write about people, people's life, people's activity, people's characters. And of course, it's always a huge problem now whether journalists can just simply name a person, a hero of this publication, or just use a picture to illustrate this publication, whether this will not constitute a violation of personal data law. And in Russia, it's now a raising problem because people who cannot bring a defamation case, they complain to authorities saying that my name was mentioned in this critical publication, and I really, really want you to punish this media outlet, this blogger, this journalist. So he would not even name me. He would not even mention anything about my life in this publication because there is a data protection law. And the courts in Russia are still quite confused how to draw the line between personal data protection and freedom of expression and freedom of impart information on matters of public concern. And I think a lot of cases from Russia on this issue will arrive to European Court, if not already. So this is it. So I will be happy to answer questions if there will be any. Thank you.